It's time to talk about more filings in the PAC and Mountain West lawsuit.
Conference realignment and lawsuits are always in the news, so we're back on the big mountain to keep you updated.
Welcome back to the mountain. I am JY, and this is my good friend Steve. And I have been telling everyone we're going to be getting an update out on the PAC Mountain West lawsuits, and that is what we're going to be talking about here in this episode. Back on September 24th, 2024, the PAC Conference filed a complaint for declaratory judgment against the Mountain West Conference in a U.S. District Court in the Northern District of California. This action challenged the poaching penalty that was included in the 2024 scheduling agreement that was mutually agreed to by both the PAC and the Mountain West. The PAC states that this poaching penalty is an anti-competitive, it's anti-competitive in nature and also unlawful, and also that this penalty is exorbitant and punitive as it restricts competition. Before we get into the most recent filing that just occurred here last week, Steve, I do want to briefly go over what has happened thus far and kind of what the PAC is saying. You know, I don't want to jump right into that because those that haven't seen us before are maybe not totally sure what's going on. So let's take just a few minutes here to back things up here. We've talked about these details of the filing in the past. Again, I want to go over the counts here really quickly just to remind everyone what they are. So the counts brought by the PAC are as follows. Number one, a violation of the Sherman Act. Number two, a violation of California's Cartwright Act. Number three, a violation of California's unfair competition law. And number four, that this contract is invalid because of an unenforceable penalties being a part of that contract. In summary here, the PAC says that this contract and these poaching fees are illegal for two main reasons. Number one, they're anti-competitive in nature or antitrust. That gets back to the Sherman Act and the Cartwright Act that I talked about. And number two, that these penalties are unenforceable and unlawful. So we're going to talk about that a little bit more here moving forward. This case then was assigned to Magistrate Judge Susan Van Keulen, I believe is how you pronounce her name. Another judge we have to remember, Susan Van Keulen, with case management deadlines as follows. December 17th was the deadline for the initial disclosure, early settlement, and discovery plan. December 24th was an initial case management conference via Zoom. We'll get back to these dates here in a minute because they didn't really actually happen because of what the Mountain West decided to do. We'll get to that. On October 17th, the judge ordered an extension of the time for filings as follows. The Mountain West had a deadline of November 25th in order to respond to the original complaint. Then, after they filed that, the PAC could respond to the Mountain West's opposition by January 13th. And then the final reply by the Mountain West would have been on February 10th with an initial case management set up for March 11th. So, on November 25th, which was the deadline for the Mountain West to respond to this original filing, the Mountain West actually filed a motion to dismiss this complaint. That dismissal hearing is set for March 25th, and we went over this filing back on an episode we did on March 27th. I'll provide a real quick summary of what that is, but the rest of this is going to be the PAC's response to the Mountain West's motion to dismiss. So the Mountain West here, I'll give you some main points for their dismissal. They say the PAC has failed to state any claim in terms of any of the counts that they put forward. They're not stating any claim here. Number two, the antitrust claim fails as the PAC lacks antitrust standing and fails to demonstrate any restraint of trade. Also, all alleged harms are speculative, according to the Mountain West. And then number three, the termination fees are not unenforceable penalties. After that filing, the plaintiff actually did not meet a deadline, the plaintiff being the PAC here, did not meet a deadline to file a reply to this motion to dismiss by December 16th. Due to them missing this filing, the court then ordered a status report, which was filed by January 16th. There it stated that the PAC would meet a January 13th deadline to file the opposition to the Mountain West. That was the original deadline that I had talked about. November 25th is when the Mountain West had the file. They did with the dismissal. January 13th was then the deadline for the PAC to respond, which they did. And that now brings us to what we want to talk about in this episode. That is the PAC responding to the Mountain West's request for a dismissal of this case. So I know there's been a couple people gone over some of this. Of course, we like to dive a little bit deeper maybe than most, and so that's what we're going to do now. So the main points here that they hit in the very beginning introduction, couple points. Number one, the Mountain West motion is based on a false premise that the poaching penalties are ancillary to the scheduling the football games, and they use this word ancillary a lot. They say it's kind of to the side of what this scheduling agreement really was meant to do. Number two, the PAC complaint is full of facts that establishes harm to competition and anti-competitive behavior. So again, the Mountain West is saying they don't have any claim, they don't have any facts, that's not even here. Of course, the other side, the PAC, saying, yeah, it's all over the place. What are you talking about? Number three, the Mountain West arguments about the unenforceable penalties are factual disputes that cannot be resolved in a motion to dismiss. So I want to talk about that with you maybe a little bit more, Steve, here. Let me finish going over this. I got a couple more paragraphs to do. But certainly, and it gets back to kind of what a motion to dismiss is versus an actual hearing. And that threshold to get to a motion to dismiss, much more difficult. So I want to hear from you on that. So within the factual background piece of this, the PAC claims that the Mountain West forced anti-competitive penalties onto the PAC. They claim that these were added over the PAC-12's objection and were to restrain competition for the Mountain West. Also, while the agreement states the PAC will receive confidential information and unique access to Mountain West members, the PAC now says that's not true and they never had any such confidential information. They go on to say that the Mountain West already seeks to impose tens of millions of dollars in exit fees to departing members. We know about that. We know there's another case that's already involved with 3 of the departing members about their exit fees, but they're basically just saying that those fees would provide sufficient compensation for the losses. They don't need both of them. They point out that the Mountain West does not bring up the exit fees in their filing. Okay, I'll give a little bit of my opinion here. The PAC here doesn't bring up those lawsuits in this filing either, right? So it's kind of do as I say, don't do as I do from both sides, right? The Mountain West isn't bringing up the exit fees. Well, the PAC's saying, hey, they're getting the exit fees. Of course, they're not bringing up the fact that those are also getting litigated. So it's a little bit of a do as I say, don't do as I do type of deal. The PAC goes on to state that they have sufficiently stated antitrust claims. They say that poaching restrictions are generally illegal. They basically go on with several pages of this case that they try and say prove that this should not be dismissed. They cite, of course, a lot of past legal precedents and all that kind of jazz. A lot of this document really is about that anti-competitive claim. Finally, at the end, about 2 of the 33 pages, they get to the unenforceability of the penalty, which to me is the beefier part of this. I'll be honest with you. That's JY's opinion. I feel like that's where they have a little bit more possibility to gain some traction here. But most of this document's all about the anti-competitive nature of poaching penalty. Here, in terms of the unenforceability, they state that the penalty bears no reasonable relationship to any damage the Mountain West is likely to suffer. As such, these liquidated damages are unenforceable. They go on to state that these fees do not function as an alternate form of performance. You hear that phrase, alternate form of performance a lot when we're talking about liquidated damages. I know I bring up the ACC FSU case and people say this is nothing like that. Actually, no, there's a lot of similarities, and this is one of them. When you're talking liquidated damages, alternative form of performance, all that unenforceability of a penalty, that's all in the FSU ACC lawsuit. There's more to it than that, but that's a big chunk to it. Remember, this was the PAC's response. This filing was the PAC's response to the Mountain West motion to dismiss. It really does not go further into much more than what their original filing was, other than just to kind of continue their argument of where they're at. Of course, they're on complete two different sides. Now we wait until February 10th, which is when the Mountain West can reply to this reply of the motion to dismiss. And then, of course, the hearing on March 25th. So, Steve, I laid it out. People want to hear from you. What are your thoughts?
So I have quite a few thoughts here.
Good.
But first, I want to confirm something with
Yes.
you. Can you remind me again,
Okay,
and remind our listeners, where this was filed?
This is in federal court in the northern, let me go back up here, the Northern District of California, okay. Federal court. Yes.
And I think that's significant, and people need to understand, the difference between state court and federal court.
Yeah.
Now, this case is based on, the PAC's lawsuit is based on the Sherman Act, which is a federal antitrust act, but they also talk about various California acts.
Right.
So, one, I think they're really focusing on the Sherman Act for two reasons. One is it establishes it as a federal case. Yes. Okay, so which is what they're filing. They have a reason. We talked about this before. Plaintiffs will file cases where they want them to be heard.
Yeah.
I think they have a reason to file it in federal court in the Northern District of California. And in order it to be for a federal case like this, the easiest way is to cite federal antitrust legislation. So right. I think that's a big part of it. But they are also going in on, with various California acts. It'll be interesting to see how that's handled. We followed before the previous PAC litigation when they right. were dissolving, and then we've been following the Florida state case in the state of Florida. So it'll be interesting to see. I mean, yes, it's some state law, but it's a federal court in the state of California. Right. So it'll be interesting to see how those are held. Now, you mentioned you were curious of why they spent so much time with the Sherman Act stuff and then didn't get to the unenforceability of those penalties. Right. I have a thought on that.
Okay.
One, I think the thing is with the Sherman Act, if we've never seen, as far as I know, we've never seen penalties like this. We've seen where where the schools have to pay penalties when right. they leave.
Right.
But as far as I can tell, and I've looked back through all kinds of cases and teams leaving conferences, we've never seen this where one conference tries to penalize another conference. And it was unique at the time when they created this agreement.
Yeah.
We kind of talked about that. We've never seen this happen before, an agreement right. between two conferences. So to me, that's their kind of moonshot. If they can just, they might be able to pop this balloon, put a pin in this balloon quick and easy. If the court says, oh, yeah, this is an obvious anti-competitive, right. Antitrust violation, boom, it's gone. Then they don't have to go through, when you look at the unenforceability of the penalties, right. those are more matters of fact,
sure, right.
most likely, where you have to go through, okay, what are the penalties? What are they based on? How were they agreed to? How did you come up with these numbers? Which is probably which would end up, if they go all the way through, be a beefier portion of the case.
Right.
But if they can hit that home run shot right away with the Sherman Act, then it doesn't even matter. They don't right. have to get into all that. And they don't have to defend why did they sign a contract and agreement originally
right.
that they're now saying was unenforceable and all that anyway.
Right.
So that's to me, it's interesting because it's the first case of this type. And to see, does that Sherman Act, does the antitrust defense, does that hold up and just pop this whole thing? That was one part. Now another thought that I had, and we talked about this with the FSU case. This is really like a divorce hearing. Okay. Yeah. We see all the time where a couple divorces and they're suing each other, fighting over assets, whatever. And that's what normally happens with these type of cases. Well, this is a case where not only are the two parties suing each other, well, now you have one party is basically suing the cheating partner, kind of,
right.
of the spouse.
Almost, yeah.
So which is interesting. Again, it's just a kind of whole new world. But I really think a lot of these cases, when you boil them down, you can look at them as basically like divorce cases that we see happen all the time. And then my last thought is, I think that somebody's going to pay something. We don't know what it's going to be. This is a negotiation. I don't think we'll go through the entire litigation, but they're going to be paying each other. They both, they tried to come up with an agreement to protect themselves each. And, it didn't work out. The whole thing blew up, and someone's going to have to pay somebody, but we don't know where that's going to go. However, my concern is how long this drags on and how it affects both conferences. They're both in vulnerable positions. We talked about this. They could have joined together and made a really, really strong conference out west. Sure. Now, in this situation, they've created two, I think, and I think you agree, weaker conferences than could have been formed. How does this continuing litigation hurt both of the sides? Does it extend things? Does it keep them from gaining new members? The PAC. Well, both sides would want to use this money to add their additional members, pay them, help them pay exit fees, all of those things. So how does dragging this out in litigation hurt both sides in what they need to do, which is consolidate their membership, get their new media deal, and move forward? Right. So those are my main thoughts on this.
Yeah, well, I think I have a couple comments based on your comments. So the first one you talked about, the plaintiff kind of picking, if you will, their choice of venue. We've talked about that in the FSU ACC case. And clearly there's a reason why they chose this venue. Now, the PAC is in California, the home base is in California and all of that. But I think there's more to it than just like, oh, this is where our home base is. Like, there's more to it. There's a reason why they picked this court. And that leads me to what you said as kind of their home run hit is if they can get this done because of anti-competitive in nature, they don't have to, nothing else matters. Yes. You don't have to talk about your unenforced. So I think you nailed it there, because if it's that, nothing else matters. Yes. You don't have to talk about it because it's irrelevant. It's anti-competitive. You're Dunskies. Yep. And maybe this was the venue they chose for that reason. I think you bring up an excellent point there. The other thing, two more things. I'm going to make a comment and then I want to ask you one more question. So if there's no dismissal, and we saw this with the first PAC case, they weren't close to settlement. We think this and we think that. Well, sure enough, when Judge Levy said, nope, this is going to go forward, then especially when the Washington State Supreme Court said, we're not going to hear this on appeal. If I'm remembering, I think it was the Supreme Court there. That's when it was like, all of a sudden, wow, we got a settlement pretty darn quick. They didn't want to be at the table. Then maybe we'll get to the table. And then not only are we at a table, we're figuring this out. I don't think that happens as quickly in this case. But I do think if there's no dismissal, personally, I think the Mountain West right now feels like they have a very strong case. They don't need to settle for anything other than what's in the agreement, or maybe a little bit less just to get the damn thing over with. Of course, we're all willing to do that. Should be. But nothing dramatic, not 50%, 60%, nothing like that. But if it's not dismissed, and then we start moving down this path more, not that they're still not confident in their case, but now you've taken another step towards, a hearing, another step towards spending money on all of this. And so that may bring the parties closer to a settlement, at least closer to getting at the table, because from what I'm hearing, it's not even on the table right now. Settlement is not being talked about by these two sides. And I think the Mountain West feels that they're in a very strong position. The PAC, I know PAC fans think that too, but I know for sure Gloria Nevarez thinks they have a really strong case. So I just wanted to bring up this, kind of what we saw with the original PAC case here a year and a half ago, and how some of these minor steps along the way. And to be clear, if this isn't dismissed, it means nothing about the case. It just means the case is going to be continuing and heard. I don't want anyone to be like, oh, the PAC won this. It's not dismissed. It's hard to get a dismissal. Yeah. Dismissals are not easy to get. It needs to be kind of a home run. So, I would just tamper down. If it is not dismissed, that really doesn't speak to the case a whole lot, other than, okay, there's enough here. And I think the PAC makes that point. There's factual matters that need to be heard. I do think they make a good point in that. So I don't think it's going to be dismissed, but any thoughts on that?
I don't think it'll be dismissed either. I don't see any world where this is dismissed unless there's just something we don't know. Some kind of weird way they wrote up their complaints or whatever, like we saw in the FSU case where they had to refile.
Yeah.
But I don't think it's dismissed. But excuse me, I will say if it does go forward, I think there's pitfalls for both sides. If you remember in the Florida State case, we were able to kind of, based on Judge Cooper's questions, we were able to figure out kind of where he was going.
Right.
So if it does go forward and we start to have these hearings and the judge is really focused on Sherman Act, anti-competitive things, then that will, you would think the PAC would feel confident at that point.
Right.
But if those kind of get dismissed, if the judge telegraphs that that's dismissed out of hand, and he really wants to focus on the unenforceability of the penalties, if he's asking, why did you agree to this contract if you didn't think it was enforceable, whatever, then that puts pressure on the PAC. So I think I think it's going to move forward, and I think there are danger zones for both sides. And as the hearings move forward, if this judge is anything like Judge Cooper, then we'll be able to and I forget the judge that he retired up in Washington State. It was similar things where Judge Levy, you could right away in both cases by things the judge was asking. Kind of go, you could see where he wanted to go in this case. And so at that point, I think we'll have a better idea of who has better standing, who should be nervous, and who maybe says, okay, we need to settle.
Very good point. The last thing I want to ask you, Steve, and it comes up, I didn't really talk about it here, but you hear it a lot, that the PAC says we were under duress. We were forced into this agreement. We didn't have any other options. Again, we were under duress. How does that play for you, Steve? We have not talked about this. How does that play for you?
I mean, well, we talked extensively before about the PAC situation and about the remaining two.
Right.
And I mean, obviously they were under duress, but that's not the Mountain West. The way I think, yes, they were under duress, but that's not the Mountain West problem.
Sure.
They were under duress. They entered into an agreement. Now, sure, they can make all the legal arguments of why that agreement was not enforceable, whatever. But I mean, you could say you're under duress, but you reached out to another conference to make a deal with them. Right. So to me, that's not part of the case at all, because the Mountain West was not holding a gun to the PAC's head. Right. The other members left the PAC. Right. Mountain West was cruising all along on their own. Right. This is something that the PAC wanted to do. To keep themselves afloat. They weren't forced into this. They weren't coerced, as far as there's nothing I can see that they were coerced into this. So
and that comes back to the one point I did talk about, where they're saying we objected to this poaching penalty. We objected to this, but they still were adamant that it had to be in. And to me, that's the same answer. You still didn't have to sign this agreement. Now, I'm not saying that means that it's not anti-competitive and that the penalties are enforceable. I'm not saying any of that. But hey, here was the deal, and if you didn't want to agree to it, then you go and find. I mean, clearly your plan B, the plan B, was worse than agreeing to this contract,
right?
With the poaching penalties in. Now, whether or not they're like, we'll litigate this in the future or not, whatever. But clearly your plan B at the time was worse than agreeing to this contract. And again, I kind of couched the duress piece around that as well. Okay, maybe this was plan A and plan B was way down here. You just didn't even want to have to look at trying to go to a plan B. Okay, fine, but to your point, that's not the Mountain West fault, right? No. So, I mean, do you have any other comments on that?
I have two other thoughts on that. One is if they really try and play we were under duress, we were coerced, whatever, there's two defenses to that. One, for this upcoming season, they were able to create a schedule.
That's right.
They had to be creative, but they did it.
Yeah.
So they could have done the same thing the year before. There's always opportunities every year, which they demonstrated this year, to create a schedule, find FBS opponents, they did the creative thing where they're going to play home and home,
right,
which we've never seen before. Mm-hmm. So I think that's, and the other part is, if they're saying they were under duress, they were forced into this, I think the Mountain West could counter and say, well, again, you came to us, and really the argument could be made that you were kind of the fox trying to get into the hen house, because you came in and now you you use this as an opportunity to get into the hen house, and now you're taking some of our members. So I don't think that's a good path or avenue of defense. The much better thing is again the Sherman Act first, the antitrust. And you can say, if they say, well, why'd you enter into this if you knew that it was, and you could say, well, we didn't know at the time. As our lawyers have had more time to review this, whatever, we realized this, was a violation, blah, 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 blah.
Right.
That's the better path. And then if that doesn't work, to attack the enforceability of those poaching penalties. But we were coerced, we were, that I just don't think it's going to hold water.
Well, and I'll just say, last thing I'll say is, not only did they then do it, they put the Mountain West under duress. Right. They went down to 6 members. Right. They were in the same duress, if you will, that the PAC that they're claiming they were in.
Yes.
And they put the Mountain West in that, and the Mountain West has now figured things out. They've added members and all that kind of jazz. That whole duress thing it rubs me the wrong way, because there were other options. It just wasn't their number one option. They went with their number one option.
I just don't think it's a good argument, and not very easily defendable.
Yeah, for sure. So, all right. Appreciate it. So here we go. We're back at it. Steve's back, having a good discussion. Mountain West and the PAC. It's what we do on the Big Mountain. Make sure you give this one a like. Subscribe if you like our content. We'll see you all next time on the Big Mountain.